All right, let's go ahead and get started, everybody. Thank you, and welcome to FPF's special webinar series, where we're going to be talking about privacy, EdTech, and students with disabilities today. Kind of an interesting intersection of a lot of different. And so what we'd like is for you, if you have questions throughout the presentation, to go ahead and feel free to leave them in either the chat box or in a Google Doc, for which there is a link in the chat box. Go ahead and leave us your questions. You can do it anonymously and we'll get them answered for you. But really with that, I'd like to go ahead and throw it to our first pair of speakers, actually. We have with us Meghan Whittaker, the Policy and Advocacy Manager at the National Center for Learning Disabilities, and her colleague, Ace, who is the Personalized Learning Partnership Manager, also at the National Center for Learning Disabilities. So Meghan and Ace, we're going to go ahead and, yeah, it looks like you're both ready to go. So go ahead and take it away. Thank you.
Great. Thank you so much, Tyler. And thanks to everyone for giving us the chance to talk with you today. We're really glad to be here and talk about some issues that are really important to the work that NCLD does. As Tyler mentioned, my colleague Ace, who you'll hear from shortly, and I are both at the National Center for Learning Disabilities. And NCLD's mission is to improve the lives of the 1 in 5 children and adults with learning and attention issues in our country. And we do this in a number of ways. We engage with parents. We build the capacity of educators. We work on developing young adults into advocates. And we strengthen the field through research and partnership. And what Ace and I really are closely tied to is our policy efforts. We inform policy efforts both nationally and locally. And for the last, I would say, nearly 4 years, NCLD has managed and operated a website called understood.org on behalf of 15 nonprofit partners. And Understood is a free, comprehensive resource that's really meant to empower parents of children with learning and attention issues. And for those of you who maybe haven't dived too deep into the world of disability, but you want to learn more, Understood has a ton of great resources that are really digestible on a variety of topics that would be a great place to get started to better understand some of the issues that I'm going to talk about today and make sure that your work is informed by experts in this area. And as I mentioned, the work that Ace and I are most closely involved in is NCLD's policy work. And we work on national campaigns to advance systemic change. And we educate and work with policymakers at the national, state, and local levels to really drive the policy debate and build consensus. But to set the stage for today's discussion, I think it's important to first take a step back and think about where we were and how far we've come for students with disabilities. Before you can really talk about what's happening in schools today, you have to understand kind of how we got to where we are. And before 1975, some states actually had laws prohibiting students with disabilities from even attending public schools. They were often institutionalized, and students with disabilities just didn't have the same rights as those without disabilities. And so that is the place that we began, and that is where the advocacy efforts really started. But today, you know, fast forward decades, after a number of laws have been passed, more than 70% of students with learning disabilities are in general education classrooms. So that is a really seismic shift in the educational experience that children with disabilities have had over the years. We need to keep in mind all of that as we think about what it means to have a disability. From a legal perspective, whenever you think about meeting the needs of children with disabilities and complying with the legal requirements, there are 3 laws that I think are really important to think about. The Individuals with Disabilities Education Act, which you see on this slide, was first passed in 1975, is probably the biggest law protecting our students. There's also Section 504 of the Rehabilitation Act, which was passed actually just a couple of years before IDEA. And then there's also the Americans with Disabilities Act, which passed in 1990. And while these laws do differ in some ways, the really important thing to know is that they first prohibit discrimination of students with disabilities. And second, they require access to the same kinds of educational opportunities that other students without disabilities are offered. And IDEA is really the foundation of special education in the United States. IDEA requires the inclusion of students with disabilities in all public schools. They have an obligation to serve all students. And there are a few key rights that IDEA guarantees that I think are important to know. First, schools must actually find and evaluate any student who is in need of special education services. That means they must provide an evaluation at no cost to that child or family. Schools must also then provide a free and appropriate education, so that's a unique education specific to that child's needs, to all of those students who qualify. And they do that through what's called an individualized education plan, the IEP. And finally, parents also have rights under IDEA. They have a right to participate in that evaluation process and in the design of IEPs for students. And they also have legal recourse if they disagree with what the school is proposing for that child's education. So these are really fundamental rights that everyone should be aware of when it comes to the education of children with disabilities. And IEPs can provide that specialized education through a number of ways. It could be through specialized instruction for children, so specific curriculum like multisensory reading instruction or other forms of content delivery. It could be through related services such as speech, language therapy, occupational therapy, or some other kind of outside service outside the classroom. It could be through accommodations, extended time on tests, or getting a copy of written class notes. And it could also be through assistive technology, which I think is probably a really big component of what the folks on this webinar are thinking about, through audiobooks or recorders or other kinds of technology that really support learning. And the other two laws I mentioned, the ADA and the 504, those are civil rights laws. So they prohibit discrimination against students, and they require reasonable accommodations so that students can actually access the curriculum and participate in the classroom. But they are not quite as extensive as IDEA. They don't provide the same sort of specialized instruction, but together, all of these laws make up a framework. These are the three laws that really set the stage and protect and provide services to students with disabilities, and also give schools and districts a roadmap to really serve those students well. So who are these students that we're talking about? There are about 6 million students with disabilities in our public schools today. Ages 5 through high school is generally who we talk about when we talk about students with disabilities. And this graph that you see here really breaks down the types of disabilities that our children are dealing with. And the ones that I think they're the most common or the biggest groups of students are those with specific learning disabilities. And a lot of those are the kids that NCLD represents and advocates for. And that's 38.8% of our disability population in public schools. And then what follows that category is the next largest is speech or language impairments with 17.3% of students. And these are often what we call high incidence disabilities. These are students who are largely in general education classrooms, spending most, if not all, of their day in those classrooms and really interacting the most with general education teachers. And on top of this pie chart, there are another about 1 million students or so who have 504 plans under Section 504 of the Rehabilitation Act. So quite a big number of students across the country who receive special education services or otherwise have a disability that requires some sort of accommodation. And as I mentioned earlier, more than 70% of students with disabilities spend most of their day in general education classrooms. That means that they are being instructed by general education teachers. And the problem that we face is that general education teachers have not gone through a lot of college courses or professional development that really prepares them to understand disabilities and to work effectively with students with disabilities. Most have not really taken more than a single class on disability while they were in their teacher preparation program, but yet we still expect teachers to be able to teach all students effectively. And so this is a really big challenge that we're facing in schools today with the diversity of our student body. And in reality, about 70% of teachers in elementary schools feel they don't have the resources that they need to provide good instruction or any of the supports and services that children with disabilities need. And actually about a third of our teachers believe that what we typically refer to as a learning disability, they sometimes call laziness. So there's a real misunderstanding here about what it means to have a learning or attention issue, to have a disability. And I think that really leads us to some of the biggest problems facing students with disabilities in schools today. That lack of knowledge and the lack of understanding that a lot of educators and other adults in the school building have can really turn into a stigma. We tend to develop misconceptions about what children with disabilities, who they are and what they need from us. And then that stigma in turn, it turns into a lot of low expectations. When we misunderstand and perpetuate stigmas, we begin to set lower expectations and set these beliefs about what we think children are capable of and what we think they're not capable of. It is really a myth that students with disabilities cannot achieve at the same level as their peers. The truth is that research shows more than 85% of students with disabilities are capable of meeting the same exact high standards when they're provided with the right supports and accommodations. That means that 85% of students with disabilities can and should receive the same curriculum, the same content, the same assessments, and the same opportunities to high-level courses and to graduate just like every other student. And that leads us to the final challenge that I'll mention, which is access. In the most basic way, when we talk about access, we're talking about access to content in general education classroom. So often students with disabilities are placed in segregated settings where they're separate from their peers. Many of them are disciplined at higher rates and removed from the classroom at higher rates. And all of this has a really negative impact on their learning, especially when you talk about students with disabilities who are Black or African American, Hispanic. Any students with disabilities of color face these consequences at much higher rates. And so these are really big issues that confront them every single day. But we're also talking about access to not just the general education classroom, but to higher level courses, to honors classes, to AP classes. Those are things that we often talk less about because there is a lot of stigma, and many people believe that children with disabilities probably can't do those things, but we know that's not the case. And most classrooms today are not designed in a way that offers all students true and meaningful access to curriculum. Whether you're a student with a disability or not, we all learn in very different ways. And we often refer to the principles of universal design for learning, and that's kind of seen as a gold standard in education. In a classroom that really follows UDL, content is presented to students in multiple ways. Students are given multiple opportunities to engage with that material, and then multiple ways that they can present back to an educator and demonstrate their learning. And this type of designed learning environment really ensures that all students, those with disabilities and those without, have access and can meaningfully engage in the classroom environment. But when you combine low expectations and this lack of access, the reality is that we're not fully including students with disabilities in our classrooms, and we're not really offering them the chance to engage with learning, to grow and to thrive. And so these, to me, are some of the biggest challenges facing us, and I think that there's a really big role that education technology can play when we are approaching it from the right way. And so with that, I will turn it over to Ace to talk more specifically about how technology and privacy issues interact with these disability issues that I've mentioned.
Thanks, Meg. Can everybody hear me?
Yeah, we can hear you.
Oh, great. Okay. So I'm going to share, it's so hard to share 3 years of your life in a matter of 10 minutes, but that's what I'm going to try to do. So there is research, and we have a whole body of knowledge that we can share with you all on this in terms of literature reviews. I'm just going to share with you our findings for the last 3 years of our work in terms of personalized learning initiatives, and translate that and connect that to technology and data. So this is a real moment of opportunity for us, and people who have been just challenged in terms of how we've done and those outcomes that Meghan mentioned have seen real promise and like opportunity here. So technology itself can help us identify and pinpoint student needs, where their specific challenges are. We can also increase accessibility to different sorts of learning opportunities and reduce stigma in that process. We can improve achievement and engagement of outcomes, providing students opportunities to learning experiences that they wouldn't have had before. We can pinpoint more closely different measures of achievement and get a holistic picture of how a student is doing and how different actors within that student's life are affecting their achievement. We can help reduce costs and increase efficiency. But Meg, if we can go to the next slide. That's not a guarantee. What we have learned, I think, over the course of the last 3 years is that some of those opportunities that we often point to are the promise of these personalized learning efforts and technology, but they can only be realized if we're intentional and proactive about that. So when we're talking about pinpointing student needs, we can also see that in technology, we miss some of the social cues that help us identify a disability and the challenges that students have. We can, instead of increasing accessibility, we can decrease accessibility by stigmatizing certain students that are using different sorts of technology or that don't have access to a specific platform because accessibility features aren't built into it. We can have students, in terms of, in the name of different pace, actually make excuses of why students with disabilities should go at a lower pace, which really there is no excuse for. We can reduce engagement and decrease some of those outcomes. We know that in terms of accountability, that often we don't have access to a lot of the data that comes off of certain tech platforms. So for example, in a lot of the virtual ed programs, data tends to be proprietary, or you don't connect that data to a specific student with a disability. So it's hard to, but there's a black box in some cases in terms of ed tech and students with disabilities. And where there isn't, we just fall short in terms of holding ourselves accountable to those outcomes. And when we're not, don't have accessibility built into these systems at the fore of efforts, we can actually add cost inefficiency rather than efficiency. So the question for us is, how do we do better? And here I'm going to frame this conversation in terms of three different things. There's one, EdTech, and EdTech can just provide different sorts of learning opportunities that I'll go through, but it can also help us facilitate an experience where we have better and more and richer data on students. And so that's for every student in the system. But both of those features that I'll talk about have certain implications for kids with disabilities. And so if we can go to the next slide. What we need to do to begin this conversation is to break down the word technology. Technology is not this monolithic thing that, you know, we should have more technology, like we should have more oxygen in the air. But the question is, what's the different type of technology for what purpose and how inclusive is that? So here I'll break down technology into three different uses as it relates to kids with disabilities. There's the accommodations that Meghan mentioned. The read aloud programs and other sorts of programs that provide students access to the general education curriculum. There's learning enhancement. So Meghan mentioned how many of our students with disabilities are in general education classrooms. So when you unveil a new form of technology, whether it's trying to integrate Google Docs more into your school, coding classes, video cameras, whatever have you, those students with disabilities in the classrooms will also experience that technology. So the question for us in terms of whether that technology will lead to greater engagement for those students or greater opportunity gaps is one of whether we build accessibility into this. And then the last is the learning environment as a whole. So technology as a whole, whether you're talking about virtual schools or blended programs, can actually fundamentally change the learning environment for students. And that could be either positive or really challenging for our students with disabilities. If we can go to the next slide.
These are pork spare ribs, like the kitchen crew at New Orleans.
I'm hearing someone's order on at a drive-thru, I think. So the key considerations for disabilities that we want to make sure that are at the fore of this conversation is one around this balance of anonymity, personalization, and accountability. So if you have a school with only a certain low number of students with disabilities, the more we personalize data, the more those students lose that anonymity. And that can include in terms of the broader, how we report data to the public, but it can also include challenges within a school. It's harder to hide that kid who's having some troubles, who has a disability, if your sample size is really, really low. So there's that balance there in terms of anonymity and personalization, but also one of accountability. We can't use that as an excuse to take a step backwards on accountability and not account for hold ourselves accountable for the performance of all students. Then there's an issue of technology in terms of which students are we talking about? When we say, Meghan showed that pie chart with all the different sorts of disabilities. So if you're implementing a certain type of technological intervention that provides students with vision impairments support, that same type of technology could provide too much stimulation for somebody who has ADHD. So the question for us is, what type of technology are we using it, and what do we gauge as effectiveness under what circumstances for what students? Another consideration is to think about accessibility, rigor, and capacity. So are we just basically taking dumbed down worksheets and putting them on a computer screen and calling that innovation and technology? Or are we putting higher levels of learning, deeper levels of learning for all students? And if that level of rigor is available for all students, then do we also prepare our educators to deliver on that for all our students? And then lastly, the point that I think that we should note is that our innovation in some ways has outpaced our policy safeguards. So there are certain things that we need to note in terms of students with disabilities and to clear benchmarks for IDEA are not incorporated, for example, in most states in terms of their guidance and overseeing their virtual education programs. You can't bind those kids on child bind. And these are all things that in the next reauthorization of IDEA and other laws have to be addressed if we're really to deliver on equitable results and equitable opportunities for all our students. We can go to the next slide. So here's one framework that we thought about in terms of how do we address this issue. So one, as we're thinking about whether it's data systems or technology, the origin of the investments should account for the needs of all students with disabilities, and not just their needs, but their higher level learning needs. So if we're saying that we need certain knowledge, skills, and dispositions for all students to succeed in the 21st century economy, that vision has to be also applicable for our kids with disabilities. And in that design phase, we need to make sure that the companies that are creating these EdTech platforms have experts and user test these platforms with kids with disabilities to make sure that these are truly accessible for students with disabilities. Then in the procurement process, we need to have our states and our districts be explicit. Don't imply it, but just be explicit about what the specific purchase means for kids with disabilities, and make sure that the individuals that are charged with making the decision have the expertise in place to know that we're following through. Then once you even get the perfect platform in a school, there's of course the issue of usability. Do your teachers know how to use these different platforms for their intended use? And are they interoperable with other systems that you have in place? And then lastly, what's the system that we have in place to continue to fund our investments and learn from them so that we don't make the same mistakes, that we learn and continue to build on best practices? We can go to the next slide. So in terms of our recommendations, there's one, this issue of transparency. We really should all be at the very least demanding sunshine in terms of the production and the outcomes of our technology. We need to make sure that we are holding ourselves accountable, and that these uses of new technology in our schools don't become a new avenue to track our students, and that we're providing all students access to high-level content. We need to make sure that if we're procuring technology, that there's a plan in place at the very outset to make sure that our educators know how to use that tech platform, not just for your average student in the middle, but our students at the margins, so that all their needs are being met similarly. And then to make sure that that technology is not only rigorous technologically, but also built into a pedagogically accessible investment, so that it's not just the bells and whistles on the technology, but whether the teachers in your school, the educators, can use that technology to its maximum benefit for all students. And then lastly, I think the thing that we've come out with our work is that this is a lot easier when you do this at the front end. We've seen a lot of retrofitting and personalized learning systems more broadly that we need to be able to address, that we need to be honest about. That this is the beginning of a movement, and in that beginning, we need to think about our kids with disabilities at the outset rather than later. This is an opportunity to really change the paradigm in this conversation, and looking forward to your questions and your thinking and your partnership as we move forward with that. So sorry I ran a few minutes late, but thanks for your time.
Great, thank you so much. Really appreciate it. We actually have a couple questions that got dropped in the Google Doc, and I'd like to take a minute or two and address as many of those as we can. If we run a little short on time, what I'll do is we'll talk about the rest of them with any remaining time that we have. But I wanted to kind of put the first question that we have in there to you both. What are some specific examples of how EdTech companies can help further the benefits of their products for kids with disabilities and avoid some of the challenges raised by ACE? Have you seen any specific examples?
Yeah. I think that the biggest thing is, what I mentioned, just user test the product, and then often, talk to developers, and they say, I can visualize what it means to make this product accessible for someone with visual impairments or physical impairments. But when Meghan mentioned that a lot of our educators don't have training in terms of being able to use technology, educate students with disabilities, especially those invisible disabilities, that's doubly an issue for our tech developers. So I think from the very outset, to make sure that you have some disability expertise when you're and developing it. And then once you have it, to user test it with students and their families, to make sure that the educators, to make sure that this is really getting at the benefits that you think of, and that there's not some user testing that could bring a challenge for that.
Great, and just kind of a follow-up question on that is who can, you know, kind of various stakeholders, whether it's teachers or companies or district or state level officials, who can those folks engage with in order to gain the disability expertise that they need in order to really understand the technologies and the communities that they're dealing with? I mean, obviously NCLD is one resource, but how can folks really get engaged and get plugged in?
So there are a few different organizations that are helpful. I mean, we can be helpful, and you have our contact information, and we can be a connector to others. There's also other organizations like CAST, UDL-IRN, and several other organizations that really do explicit focus on accessibility, depending on the product that you're talking about. And there's also guidelines out there and different things. So the web content accessibility guidelines are a good step. So that's the best I got. Meg, do you have anything to add to that?
No, I think that's it. I think really reaching out to organizations who do this work and reaching out to your local community as well. I think parents are eager to be engaged where they can and to be a voice for their children. And so if there are councils or committees or groups already gathering to make decisions about special ed or to provide input, like reach out to that community and let them have a say and kind of help guide that work and make decisions as well.
Awesome. Thank you. So kind of looking at things, what we're actually going to do is we're going to take a crack at answering the rest of those questions in the panel afterwards, because I'd like to move things along and thank both you, Meghan and Ace, for coming on and helping us understand this stuff. But I'd like to move things on now to David Rubin. David is a private practitioner who represents numerous school districts, and he's going to talk to us a little bit about his kind of experiences working with district level folks. So David, are you with us?
I am with you. Thank you, Tyler. And
All right,
thanks everyone for joining us. I think that Meghan and Ace did an excellent job of explaining the benefits of technology and how they can serve the interests of children with special needs. I have to begin with a brief disclaimer. I'm not an educator. I don't consider myself a techie. I was practicing law 20 years before the first web browser was even invented. So my job in advising school districts around the state of New Jersey is to try to explain some of the legal framework you've already heard about, but also to interpret that in the context of a broader legal framework of student privacy that applies to all students. My colleagues mentioned the Education for All Handicapped Children Act that was adopted in 1975 that established this basic floor of opportunity for special needs children. Just within a year when that was adopted, I believe the year before, Congress also adopted another statute called the Family Educational Rights and Privacy Act, which we call FERPA for short, which was an attempt to balance the ability of families to get access to information about their children, while at the same time making sure that it was kept confidential from other people who didn't have a legitimate right to know. And as an attorney who advises school districts and consults with my colleagues around the country through the National School Boards Association's Council of School Attorneys, which, by the way, is a 3,000 or so member organization of attorneys who are involved every day in advising school districts on the issues we're talking about, we have to make sure that we are complying in implementing all this wonderful technology with the federal requirements of FERPA, and also with a growing number of state law statutes that have attempted to go even further than FERPA has gone to impose even more obligations in terms of confidentiality, making sure that data is secure, and other matters. It's a very complicated area. School districts are already very heavily regulated, and in this area, this is obviously a high priority issue. Where we see the most action in terms of questions we get from clients and areas where we try to stay ahead of the curve in the area of technology, I see several different areas where there is the most activity. One is the general issue of electronic storage of student records generally, cloud storage, if you will, which again isn't necessarily specific to special needs children. It applies, both to information stored on with students and staff, but obviously when you're dealing with a special education child who may have even additional privacy concerns, it's all the more important. We are seeing the increasing use of web-based IEP development programs. I won't mention any brand names, but I'm sure some folks in the audience are familiar with them, where IEPs are constructed online collaboratively with folks. One person may be working from their cell phone, another person may be working from a desktop, where these documents, which need to be prepared for an IEP meeting, are constructed electronically. A lot of issues in terms of privacy around that. The whole issue of just communication electronically between special educators by email, by text, and whatever, when they're talking about a child or a child's parent who may have given them, let's say, a hard time at an IEP meeting. All sorts of privacy issues around that we need to be careful of. And then the one issue that probably is the most challenging for me in terms of getting people to focus on and understand the legal implications of is the proliferation of classroom apps that some of our best and brightest teachers are on their own downloading and implementing in their classroom, oftentimes with little to no oversight by administration. And let me be clear, this is with the best of intentions. They're looking for ways to help improve their students' outcomes, but we have a lot of what I like to call unguided missiles out there in terms of technology that's being used with really no centralized decision-making approval process, and oftentimes with very little awareness on the part of teachers as to the privacy implications of the data that they are collecting on these machines. So my biggest challenge as a school board lawyer, especially one who is not a techie, is to be able to take this legal framework and, more than anything these days, change the mindset of folks in public education who, when you think of student privacy and student records, what do most folks typically think of? They think of a file cabinet, maybe with a lock on it, and an old-fashioned file that is in paper form in a manila folder. These days, when I ask my clients for a student's file, what I typically get back is what they call the file. In New Jersey, they call it the cum file, short for cumulative file, which is what is sitting in a drawer somewhere. What they don't realize is that these days, when we talk about student records, we're not even talking necessarily about paper anymore. And our biggest challenge is to try to get our clients, including folks on this call here, to be thinking in terms of data, not records. We're talking about collection of information, which may not even be in paper form, and much of which never sees paper at any time during its life. It's created electronically, stored electronically, shared electronically, and to get people to realize that this is information that also falls under the purview of these statutes we're talking about and needs to be kept private. So the analogy I try to use when I'm in front of a school district audience is, folks are using their personal Dropbox accounts. They're using these online web development tools to make sure that they can accomplish, all the work they need to get done. If you can think of a teacher who is, let's say it's the end of the day and they haven't finished little Johnny's IEP and they want to work on it at home after dinner, they upload it to a Dropbox type of a storage device. They get home after dinner, they pull up their laptop and are working on it. Little do they realize that that data has gone somewhere between when they left their desk at the office and when they've gotten home. And it hasn't gotten up into something we call a cloud, because the fact of the matter is that there is no cloud. It's just somebody else's computer. When you start thinking about the implications of sharing data in that way, even sharing it with yourself, what a lot of folks don't realize, it's almost analogous to renting a storage locker down the street, maybe even across state lines in another state, where you're storing somebody's very private information in a storage space where, for all you know, it may be commingled with other people's information. Other folks may have access to it that you wouldn't know. And once that teacher presses that button and uploads little Johnny's IEP up into the cloud, quote unquote, so she can work on it at home, for all that teacher knows, that IEP is now sitting on a server in Bangalore, India. Folks are really unaware about the implications of that because they don't think about it. And this is not to be critical. This is just a statement of fact. We're all used to technology. I know how to work my TV set. I don't know the inner workings of it. I know how to turn it on and turn it off. And frankly, that's all I care to know. And that's how a lot of folks in education approach technology too. They want to take advantage of the benefits of it. But my job as an attorney is to acquaint them with some of the legal implications of what they're doing. One of the challenges we have is, we are dealing with third parties, some of whom may be on the call here in terms of vendors and other folks who are bringing us all this wonderful technology. And again, folks are in business, they're selling a product, and I say that admiringly, not critically, but our job is to make sure that when we entrust them with our data, when we purchase their products, when we purchase their storage services, that we make sure that what they are doing is also compliant with FERPA, which does allow us to bring in partners from the outside to help us in storing and collecting information, as long as they fit within something called the school official exception to FERPA. And I don't want to get too technical here, but in simple terms, we're allowed to involve third parties in the storage and collection of information as long as we exercise direct control over them, as long as they're exercising functions that we would otherwise be doing ourselves, and as long as we monitor what they're doing in a way that we ultimately will be held responsible for if something wrong happens. That is why when we enter into contracts with cloud storage companies, with companies who are selling products, technology to our districts, we want to make sure as lawyers that there's language in those contracts that assures that our students' privacy is protected. We want to focus on making sure that it's very clear who owns that data. We want to make sure that there are provisions regarding getting the data back if our relationship with that vendor terminates. Make sure that we have vetted the company to the point where we're satisfied they have appropriate security measures in place. I could go on. I don't want to get overly technical, but my point is that oftentimes vendors will present what appear to be boilerplate contracts that have a lot of fine print that no one, particularly if they're a mid-level administrator, let's say, may have the time or inclination to read through, may not have the presence of mind to reach out to the school district attorney for advice. The message for me is that these documents, which seem like very simple standard documents, have enormous legal implications for your district, and you want to make sure that they've been reviewed by folks on staff who are responsible for procurement and have some awareness of the legal implications of some of these things. I mentioned classroom apps presents a lot of concerns. And again, let me just make clear, this is not a criticism of anyone. These are wonderful tools that can be used under appropriate circumstances in the classroom. But what we're seeing in a typical case, a teacher, again, with the best of intentions, will see some very attractive app online at night. They'll point and click, accept some terms of service that I can assure you she has not read it. If she's read, she hasn't understood, because frankly, even we lawyers can't understand what a lot of these scroll down terms of service even mean. And then all of a sudden now has on her phone an app that she's bringing into her classroom the next day. And I don't want to mention any brand names here, but that app, let's say we're in a special education class where that app is designed to monitor student behavior. And a teacher is recording information on that app. Couple of problems there to begin with, and challenges for school districts. Number one, who has made the educational decision that that app is appropriate to be used in that classroom? A lot of these apps that I've seen take very, very particular approaches toward behavior management and other issues that may or may not be consistent with the school's pedagogical approach. So there's an educational issue there about whether it's consistent with the school's approach to things that's beyond the scope of this discussion. There's also a procurement sort of an issue. When that teacher has downloaded that app onto her phone and clicked terms of service, I say her, it could be him as well, is there now a contract with somebody? And if there's a contract, who's that contract with? Certainly not the school district, who is unaware this is even being done. So again, somewhat beyond the scope of our discussion, but just to mention it because I think it's important. The privacy issue, though, is when educators are using classroom apps to record student information, we run into the same issue as I mentioned before with the teacher uploading an IEP to work on at home that night. Once that teacher records that data on that device, it's going somewhere. Once that teacher presses enter, or however it's done on a phone, as I like to say when I'm in front of groups, you know, Elvis has left the building. That data is no longer in the district. It is out there somewhere. And the folks who are allowing the usage of these apps need to make sure that they're comfortable that that data is being housed and only has access to it by people who the district is comfortable with. And training, I think, is the answer to a lot of this, because raising awareness of some of the implications I've just been mentioning is very, very important. I know a lot of the new state laws that are coming online have a certain expectation about a staff's awareness of their responsibilities, and none of these laws are worth the paper they're written on unless staff is appropriately trained. A couple of products I do want to mention, because there's a couple of success stories here. One in which I can mention, I've been given permission by the vendor to mention it. I encountered one particular piece of technology that we're encountering in districts in New Jersey these days is a product called AngelSense. I'm not here to endorse any product or criticize any product. I'm simply relating a story that actually happened. For those who are not familiar with AngelSense, AngelSense is a GPS tracking device. It's not the only one out there, but it's one that's in very frequent use here in New Jersey. usually purchased by parents of autistic children. It's a device that is stuck on the child's clothing. They send them into school and they can keep track of the child's whereabouts during the day. No problem there. The problem is that that particular product and some of the others out there in the market also have something called a listen-in feature, where the parent can listen in to anything that's going on within earshot of where that child is, including what's going on in a self-contained special ed classroom where that child may be during most of the day. Obviously, there's some privacy implications there. And in New Jersey, at least, we've taken the position that other people have privacy rights. I'm not even getting to the teacher's privacy rights, assuming the teacher even has privacy rights here, and that's an issue that some states have differed on. But just focusing on the students, we've taken the position that that shouldn't be the case. And whereas with a lot of companies, you might expect to get some pushback in terms of them changing the way their products are located, this was an example where we were able to get the president of the company on the telephone and have a very cordial chat, and we're able to actually get them to revise their standard form of agreement to allow that listen-in feature to be deactivated by the company itself, so that we wouldn't have to worry about that particular concern. My point here is that when you're dealing with ed tech companies who are coming into the district, there should be an opportunity to have these sorts of conversations, and I would counsel ed tech vendors who want to come into certainly any district I'm in to try to be open to these conversations so that you can get your products into our district where it's appropriate for them to be, and we as school board lawyers can be confident we've done our job to make sure that everybody's privacy is respected. So those are a couple of issues. We could probably continue on, but Tyler, why don't I stop there for the moment and see if there are any questions?
Yeah, that's fine by me. So we actually had a lot of great questions come in, and I'm going to highlight two for now that I think will help contextualize all of what you just said and build on it, and then we'll address as many of them of the others as we can afterwards. So the first question is number 6 in our document. How does FERPA, the federal law you mentioned, interact with IDEA privacy requirements?
Well, FERPA applies to all students, whether they are special education or general education. It fits into IDEA in that information that is collected about students, special education students, is private. It's accessible to their parents. It's accessible to educators with a legitimate right to know. It's not acceptable. It's not accessible, I should say, to anyone else unless they're on what I like to call a guest list. It's a list of people who, under FERPA, are people who are presumptively entitled to that information upon request. For example, it could be child welfare protection agencies from the state. It could be the State Department of Education. There's a list of people who are entitled to access to that information, but generally they're people who have a legitimate right to know. So the way that FERPA interacts with IDEA is by making sure that the privacy, the right of access and the right of privacy that all students have is doubly in place when you're dealing with special needs children who have extra special privacy interests at stake.
Great, thanks. And the other question is, so we've spoken about the concerns around student privacy and students with disabilities. At what point does having or collecting information about a student's disability carry us into HIPAA? As an ed tech vendor, if a school flags a student in our product as an IEP student, is that vendor now obligated to be HIPAA compliant in addition to FERPA?
Well, you're getting into an area there that requires probably a more technical discussion than we have time for, and that frankly even I may be competent to give. I would say, generally speaking, if you are compliant with FERPA and the requirements of your state privacy laws, there typically is nothing more one need to be worried about under HIPAA, because you're probably already complying with what those requirements are. A vast oversimplification of the law, but that's as much as I can say in kind of a soundbite format in this discussion.
This is Amelia from SPF. I'll also add on that FERPA actually has a specific exemption that generally information that would be covered under HIPAA, if it's part of the education record under FERPA. FERPA is the law that rules, even though HIPAA will often have a higher privacy standard. And the vast majority of times, HIPAA isn't going to cover this information anyways, because HIPAA most of the time kicks in when you're dealing with insurance billing. So the vast majority of time, you're not going to be dealing with, ed tech vendors will not be dealing with HIPAA's requirements. However, you do have a few state student privacy laws that have adopted HIPAA level security. New York, I believe Connecticut as well. So you should keep an eye out about that.
And the point Amelia makes, which I think is worth mentioning, is that, everyone's familiar with FERPA. These days, at least in the last 3, 4, 5, 6 years, we all need to be familiar as well with this proliferation of state student privacy legislation that goes far beyond anything that FERPA would require. It's state specific. You need to check out your own state legislation because, as Amelia points out, you may be saddled with requirements in your state that federal law would not impose on you.
All right. Thank you for that, David. We're gonna kind of address as many of those questions as we can afterwards, but for now, I'd like to kind of move the conversation on to Melissa Lazaro, or Lazaro. Please correct me if I got that wrong. I'm not sure, and I apologize. Melissa is the director of sales at LexCorp, which is a technology company that actually has products for a product suite for students with disabilities. So Melissa, I believe we have you on the line. I'd like to let you take it away.
Thanks, and thanks for having me. As a parent of a child with dysgraphia and dyslexia, I have found understood.org so very helpful. So thank you for all the work that Meghan, you and Ace do. And David, some really great insights. In fact, you've provoked a couple questions that I think I need to have with my CEO in terms of privacy in our product that might be specific to the United States. So thank you for that. In terms of a little bit about my background and why I've gotten into this space, I was a former professor, and then my son was diagnosed with dyslexia and dysgraphia, needed to do a financial shift, went and worked for Tesla. And in the process of finding interventions and effective technology for my son, I came across LexPlore. So I made that career shift last year. So what is LexPlore? LexPlore is a clear view of reading, and what we do is we use an eye tracker device, a Tobii eye tracker device, that you would see in any sort of gaming, and so the kids sort of like it because those that are in gaming, they think it's exciting. On the back end, we use artificial intelligence or machine learning. So we have created a model to predict a child's reading ability based on an almost 30-year study at the Karolinska Institute in Stockholm, Sweden. So we've been in operation in Stockholm, Sweden for about 3 years, and came to the United States last year and did a pilot study and began to roll out to schools. And so what really drove our product and our solution was being able to identify children with reading difficulties as quickly as possible. Our product started off by slicing up the data into 10% and then everyone else, and really focusing in on those kids that are struggling. And we have developed our product to the extent that we are able to determine 5 different reading levels in less than 2 minutes, which is very exciting. I do want to address a concern that some people have sometimes when I say the word eye tracking. Can a child have dyslexia and also have an eye tracking issue? Absolutely. Does the eye tracking issue cause dyslexia? Absolutely not. What we're doing with that eye tracking device is it's allowing us to see the cognitive processes of the brain. And so we're looking at a couple hundred variables on the back end of the machine to figure out how the student's brain is working and then predict that reading ability. That's about the simplest way I can describe it. So we know that reading ability is essential for success in school and life, but unfortunately, when we see all of these different stats that come out, specifically the most recent lawsuit in the state of Michigan, unfortunately didn't prevail, and then state of California, considering that something like almost 70% of our 4th graders are not at proficient reading level by 4th grade. So there's great concern of what is happening in terms of literacy around the United States. How can we identify these students as quickly as possible and be IDEA compliant, and also save their self-esteem and make sure that we're decreasing that learning gap. And so that's what our product does. It helps identify students at every different reading level in 2 minutes. Now, we are not a diagnostic tool, so I want to make sure that we're clear on that. We are simply addressing the need to decrease the amount of assessment that is being done by students as well as by teachers, so we can provide more instructional time and get the kiddos that need more help, more instruction, and at a quicker pace, and those that need to be challenged more in line with an MTSS model are able to be identified sooner as well. And so what educators have told us is that, you know, we really want clear real-time data and guide instruction. A lot of the assessments that are out there, some of our newer teachers, as Meghan pointed out, you know, haven't been given a ton of training in any kind of disability, let alone specific reading instruction for those that struggle. And so they want a simplified approach to how do I identify these kids, and then how could I use the training that I have to, or the resources that I have to provide the correct instruction. The benefit of LexCorp is that it's an easy assessment. We're looking at real reading, which is the most accurate assessment of reading. And because it's a 2-minute assessment, we're really focused on the reading then instead of focus and attention. So what is LexCorp? I'm going to play this video for you all real quick so you can it's a 60-second video, so you can see what I'm talking about and what I've sort of painted the picture for in words in the last 5 minutes.
Okay. LexCorp is a rapid reading rating tool. In just 2 minutes, a child's reading ability is assessed using eye tracking technology and artificial intelligence. Okay. Very good.
Hey, Melissa, I think we lost the sound on this video, actually.
Oh, is it there?
Yeah, we got it now.
To learn more, go to LexCorp.com.
Sorry, I was afraid it was going to echo because I had the sound on my phone and then also on the computer. But essentially what you were seeing there is you can see the high-level data reporting from a district level all the way down to the exact student. The recordings that you were seeing, the visualization of the recordings are the fixation time. So how long a child is spending decoding a particular word would increase into a bigger bubble the longer time they spend. The saccades, which are the small eye movements when we read, and as well as any sort of regression. So although we're considering all these other variables on the back end, the visualization that you get to see as an administrator, as a teacher, is pretty powerful, especially when we're considering children who have elective or mute, those that are nonverbal. So any of our children that are not able to perform an oral reading test, we are now given the opportunity to be able to see the fluency rate of these children, the comprehension rates of these children, as well as their RAN score and their grade level equivalent. Which, when we're considering the technology of capturing all students, this technology allows for a particular subset of individuals who we have not been able to capture their silent reading scores, which is really powerful. We can also hear the student read, which our administrators find very helpful when typically a principal is in a classroom and a child's being assessed. And so now they can go into the computer and they can listen to that. What we've done in terms of privacy to address any sort of red flags that David might be popping up with right now is we've done several things. And so let me go here real quick. We give recommendations in terms of who should have, there should be a central point of responsibility for data security, as David pointed out. Our particular company we are GDPR compliant, and what that means, it's the EU regulation that was passed in spring of this year, which is the General Data Protection Regulation. So even though we're a US company, We do have business in the UK and in Europe, and so we're making sure that we're already complying with those highest standards in terms of how we're managing personal information, sensitive information, excuse me, and and making sure that we know that it's technology neutral, and that's what GDPR is. It doesn't matter if it's on a computer or not, or paper. We have to be compliant, and so our company is. Some of the other suggestions that we think are important is, making sure that we're uploading those testing materials to a central system directly. Some of the things that David brought up, and it's to the point of, where there's all these different steps in order to gather that data, especially in an IEP. You might have a school psychologist doing some of the assessments, or their intern doing some of them with pencil and paper, and then you have, you have an online assessment that this child is doing, or a teacher getting a benchmark or a baseline. And so all of that has to come together in one place. And to David's point, that might be at home, it might be at school, it might be in one classroom or another, and that's all being pulled together. And so the more that we can pull this in a centralized location, the better. And so we see that as one of the benefits of our product, is that we're able to quickly assess these kids, have it in a centralized cloud and location with a graduated level of access. So only those with a need-to-know basis are able to access that sensitive and that private data. And going back here to, a little bit about, I think I touched on that, but actually how this works. You saw the video. We perform the reading test. We run the analysis. That is both a visual representation and data points, which produces those results. And then we make sort of recommendations for what should be next. We don't specifically state, a curriculum. We are not a curriculum embedded assessment. We are an overarching reading ability assessment, which I think is unique to our product. We have a very high level of accuracy, and so the objectivity, I think, is really important here. When you're thinking about traditional reading assessments that are done, there is always a possibility of subjectivity, of unconscious bias in terms of gender or a person's socioeconomic status or their race. And this is simply looking at the objective lens of how the student's brain is functioning and where their reading level is at. So it alleviates that subjectivity. It decreases over-identification, and less resources then are spent on hyper and costly comprehensive assessment and more time in instruction. I think it's also important to think about the fact that it's auto-aggregated data, so there's less touch points in terms of how we're transferring this data. If we're using pencil and paper, how is that data then aggregated? Who's doing it? Who has access to it? What's being done then with that? And so if you're using something where there's a central point of gathering and that's already done, there's less room for mistakes and it being passed off there. I think the other thing in terms of how this is helping children with disabilities, and in terms of my own experience and in talking with teachers and educators, that having a tool that quickly tells us, is this child making progress or not? Are these goals challenging enough? With the injury ruling, it's really important to know, where is this kid at, and are they making some pretty significant progress? And so having a tool that quickly assesses that is important, not just for financial and resource reasons, but also to the social and emotional benefit of the child. Making sure that the intervention that is being used is appropriate. And David, I had to give a little bit of a chuckle when you said, how do we know that this app is appropriate for SAI? Who made that decision? Is that a site decision, or is that, a person decision? And so I think having the tools and the technology to be able to quickly assess that and figure out what's going on with this kid is super important. And then making the determination is, is further assessment than necessary. So it's sort of this rethinking of assessment where we come in with a tool that quickly assesses and then making the decision, does this child need further assessment? You know, if they're in 3rd grade and they're in the bottom 10 percentile, what is going on with the student? If they're in 7th grade and they're bottom percentile, what is going on with the student? What sort of further assessment do we need to do to help them out? So I think that's all I wanted to share, and I'll take any questions.
Great. Thank you. Really appreciate that, Melissa. I think it's a really good example of how EdTech can help students with disabilities. I mean, it really is. I do have one question for now, and then we can throw everything else to the end. And I wanted to kind of dig into the privacy aspects of the product a little bit. So specifically, we've kind of seen a pushback against the use of biometric information, especially when it's collected from children. Kind of, for example, Florida has banned any collection of biometric information in its student privacy law. Illinois also has a general biometric privacy law. So just kind of how is your company thinking about privacy in the context of, you know, the data that you're collecting? Has the issue of biometric information privacy come up?
You know, I think that's a great question, and David kind of sparked my interest on that. Every time I've asked about the privacy in terms of, you know, where we're housing the data, how is it being processed, who has access to that, the answer that I receive from our leadership is that we're complying with European standards, which are, in terms of the cloud, that are higher than the US standards. But I think that's a great question and something that we need to consider. One thing that I do know that we have built into our product and considerations that were made in terms of working in the disability community and within education is the ability to anonymize the data. And so we do have that built into the technology, as well as who can access that. But I don't have a specific answer for you relating to biometrics, but I think it's a great question.
All right.
I'd be happy to look into it and get back to you guys on that.
Sure. Yeah, really appreciate it. And so I think that's, really appreciate you coming on and talking to us, and we may have more questions for you at the end, but for now I want to kind of make the transition over to our final speaker. Linnette Attai is the president of PlayWell LLC, and she has a lot of experience working with many different stakeholders who all serve students with disabilities. And kind of with that very brief introduction, Linnette, do we have you on the line?
Yes, I am here, and I am working on sharing my screen.
Perfect. Yeah, I'm seeing it coming through, so I'll let you go ahead and take it away.
Excellent. Well, thank you so much for having me here. I'm really happy to be talking about this topic, and I really look at it and say, you know, there are certain things we need to be mindful of when talking about student data privacy for students with disabilities, special needs students, but we also need to remember that the fundamentals of data privacy apply across the board, and certainly I see some missteps in this portion of the sector that are worth unpacking a bit. Just by way of brief introduction, as Tyler mentioned, I run PlayWell, which is a compliance consulting company. I've been working in data privacy for a very long time, and I really focus on providing strategic guidance to companies, to districts that I partner with to help design responsible pathways to innovation, to opportunities, be it in data privacy, in marketing compliance, across a variety of sectors, but my wheelhouse is really the education and youth entertainment sectors. There are a lot of regulations that we need to be thinking about when going to the education sector, and particularly when going into the sector where we are working with students with disabilities. We have FERPA, we have the Rehabilitation Act, we have Title II, we have Individuals with Disabilities Education Act, ADA, and it can be overwhelming, especially when just getting started in the space. So I like to, take a step back and really think about the similarities among the laws, and don't get too caught up in the weeds until you are really in the trenches with it. But we could unpack differences between FERPA and IDEA, with respect to, one is applying to education agencies, one is applying to schools and early intervention services, and one is discussing a student and one is discussing a child. But really, it's helpful to look at the similarities and talk about what are the common threads. Certainly, there are, some of these laws are more prescriptive than others, but the idea here is simply to note that if you're familiar with one of the regulations and you notice these concepts and these requirements in one of the regulations, note if they apply across all of them. There are some specifics to keep in mind when we're talking about individuals with disabilities in Education Act. Some specifics that are probably not covered, that are not covered in FERPA, which we're certainly used to talking about on these calls, but which I think in concept are applicable and probably should be part of any decent privacy compliance program. So in this sector, we're talking about requirements to protect the personal information across the life cycle of the data. And that we assume in other laws, but it's really baked in. A privacy officer for the schools and districts must be designated, employee training provided, and a record maintained of those with access to the personal information, also a requirement of FERPA. So for EdTech vendors, while the laws may not always be directly applicable, it's really important to understand them and understand that this is what is expected of your school or district. And so this is essentially what the school or district should be requiring of you in order to be operating in their ecosystem. So it's important to sort of unpack the laws and understand, well, where might it and might it not apply to me? Keep in mind also that under this regulation, the record of those with access to the personal information needs to be publicly available. So for those of you who are struggling with your organization to find a way to create a more narrowly tailored rule and role-based access policy, sometimes telling employees that their contact information or their name at least has to be publicly available, will limit the appeal of wanting to access the data in the first place. Other specifics that are worth noting for those who are looking to build EdTech in the space. The law here is specifically concerned with the destruction of personal information, which again, other privacy laws, are concerned with. We assume that's the concern, and they're concerned. We know they're concerned with that because of the way the laws are constructed, but they don't actually specifically call out that when they talk about deletion of data, they're talking about deletion of the identifiable information. And what we have here is a permissiveness to keep de-identified information in a sense. However, we know that de-identifying information is not as easy as it sounds, and we could spend hours just talking about how to do that properly. One of the things that's interesting as well is that destruction here can take place at the request of the parents, which is set up in a sense the way that HIPAA is set up, right? Where the parent has some rights to deletion of the data. However, the school, the education institution, the early intervention service that you're working with has a requirement to keep a permanent record of the student name, their address, their phone number, their grades, attendance, grade level, year completed. So if you are housing that data, it's very important to understand that, because when it comes to destruction of data, you need to make sure that that information has been returned to the institution, because they have no time limit on destruction of that information. That's a permanent record. The repercussions for running afoul of these laws are intense and varied. Certainly, there is the requirement for appropriate corrective action, which may include monetary reimbursement. There is potential for damages under Section 504 if a disability is known and not addressed. And then, of course, under FERPA, we have withdrawal or withholding of federal funding, and we have specific repercussions for technology providers That is, the school or district would be precluded from supplying them with identifiable student data for a period of 5 years. The reason I bring this up is that some of these are laws that don't specifically, most of these are laws that don't specifically apply to industry, but are really important for industry to understand in order to understand the potential repercussions where they could get easily sucked into a situation. And what I want to focus on particularly here are technologies that are being marketed to address a disability, to address a particular need that a student may have. Be very careful what you promise schools. The requirement is already, as we all know, truth in advertising, right? When you're making a statement, especially a marketing statement, it needs to be accurate, truthful, not misleading, replicable if you're making a claim. Understand the repercussions for a school, a district, a teacher who brings your technology into the classroom under a promise, depending on how that promise is constructed, of what it will do and the benefits that it will provide. Make sure you're being realistic. Make sure you are, have efficacy study testing, that you are caveating your claims appropriately, because this is the type of situation where if a product does not perform as designed or as I should say, as promised in marketing, and complaint is filed, and under these laws, FERPA, you have 180 days to file a complaint, you've got up to a year. In these other regulations, you may be swept in and under, or certainly gone after for issues in this regard if you've been over-promising in your marketing. And it's the reason I belabor this point a bit is that in this sector, we see certainly some good established companies that are doing work and some good small companies that are doing work in the space. But we do see almost a disproportionate number of small companies coming into the space, and perhaps a lack of knowledge and fluency in the requirements. And that is really where it can get complicated and very damaging all around. Now, the requirements are intense, and we don't have time to go through them all here, but I wanted to talk specifically about something that's happened in Connecticut, where Connecticut student data privacy law has been updated. And Connecticut is one of the states where particular contract provisions are required of education technology providers, except there's an exception that's been written in recently, where essentially if the technology is deemed necessary and unique to address a need, to implement an IEP, the contractor can't meet certain requirements of the law, if essentially the district has made a reasonable effort to enter into a contract with the technology provider that meets the requirements of Connecticut law, and has not been able to. But the provider complies with FERPA and HIPAA, and the Board of Ed has tried to find a replacement product, but has not been able to. The parent signs an agreement acknowledging that the operator can't meet the regulations and authorizes the use. And the technology provider otherwise meets the requirements of Connecticut law, but cannot sign on to the contract provisions of it. The Board of Ed is permitted to bring that technology into the classroom. And I don't necessarily agree with the way this law is constructed. I appreciate that they tried to construct it narrowly, but I would strongly caution technology providers who might be looking at Connecticut and taking advantage of this sort of loophole in the law, if you will, to keep in mind that this is an untested provision. It's not been widely discussed yet. It just came onto the books effective June. And so we don't know that if it's going to stand the test of time. So I would really use caution in thinking that maybe there's some wiggle room in some states, or wiggle room coming in some states. We really don't know how this is going to play out over time. And I always, as a compliance person, I always say, it's actually not always that hard to meet the requirements of the law. Be thoughtful about it. and meet the highest bar that you can. It's a fundamental business requirement. You can't be in the space without a strong privacy framework in place. And to do that, you really have to understand the education ecosystem, how the schools or districts are operating, how the teachers are behaving, the tension between the teachers bringing products into the classroom and the technology leadership at a school or district, not just the laws, but also how they're implemented and best practices around that, the challenges that your customers face, and the requirements of the market. Because misstepping in this arena, will get you out pretty quickly. Also, transparency is critically important. Communicate clearly, be extremely accurate, be very careful about avoiding any overpromise in your marketing. It's not legal to start with. This is an area where you could find yourself bound up in more than just truth in advertising issues, and make sure that you're committing to ongoing monitoring of your compliance program, of your data privacy practices, and ongoing improvement. And I'll stop there. Are there any questions? I'll stop sharing my screen and turn it back to Tyler and Amelia.
Great. Thank you. So I actually want to go kind of straight into the questions that we have from the folks on the call. And I think, Linnette, this first one is probably a good one for you, and maybe for David as well to hop in on. So it comes from an EdTech vendor. So as an EdTech vendor, our pursuit of strongly engaging content and activities, in other words, visual, requiring some keyboard and mouse dexterity, etc., sometimes seems to conflict with accessibility standards like WCAG. We sometimes wrestle with finding reasonable accommodations without degrading or undermining the learning experience. What's a good litmus test or general guidance on how to handle these sometimes seemingly conflicting priorities? In short, is it acceptable or even possible to demonstrate to schools the vendor's efforts by way of accessibility without having every box checked in the WCAG standard? Oh, and Ace, this may also be a good one for you. I'm not sure.
Hello?
Yeah, we got you.
Oh, yes. Well, I'm pausing only because, as some of our participants may be aware, the Office for Civil Rights over the last few years has gotten into the business of policing school district website accessibility standards. And while with the change of presidential administrations, the emphasis on that, may be changing, I can tell you that OCR, at least over the last few years, and up until very recently, had been taking a position that just using websites as an example for school districts, needed to be accessible. They're focusing on these things. If the question is there some way to get a pass just because you show you used your best efforts and tried? I'm not sure that's legal. If the legal standard requires that it be accessible, the mere fact that somebody showed a good faith effort alone, I don't think is going to get you there. The question is it sufficiently accessible by whatever objective standard applies under the law that's in place? The question is, does the law apply? What is the standard? Whatever that standard is, I think you're going to be expected to meet it. So let me that sounds like a lot of semantics, but the bottom line is just showing that you tried in good faith alone is not going to satisfy a law that requires a certain objective standard of accessibility, in my view.
All right, Linnette or Ace, do you guys have anything to add to that answer?
No, I think David really hit it on that. Like, yeah, there's not a participation effort. I think that there's just great. Like, I think that there are clear standards, and we need to meet them. And I think the better way of thinking about it is really the way we set up these systems. If they are accessible for exceptional learners like those with disabilities, when we design the systems with a universal design mindset, that they're going to benefit not only those kids with disabilities, but those without it. We see that really strongly from the research.
Great. Okay, so we have a related question. So a lot of districts have been dealing with legal mandates for more accessibility on their websites for people with disabilities. And often, unfortunately, the practical implication of those requirements has been districts and states choosing to post less information on their websites or cutting off access to certain technologies such as MOOCs. How do we deal with balancing the rights of people with disabilities with transparency, privacy, and LEA limited budget? Meghan and Ace, this might be a good one for you guys to hop in on.
While Meghan and Ace are hopping in, this is David. Let me just share with you a recent experience, because I just entered into a resolution agreement with the Office of Civil Rights on a school district website accessibility issue. And what I can tell you is that while under the former presidential, and again, I'm here not to debate presidential politics, but I think the fact is that under the prior presidential administration, OCR was taking a fairly aggressive position toward requiring strict compliance. Under the current administration, somewhat less so. And while they're still out there asking districts to subscribe to agreements committing to comply, they are usually being pretty lenient, practical. I just signed on to an agreement that gave my particular school district client, I think it's either 2 or 3 years to come into compliance. The agreement didn't even require to specify what compliance even meant. So I think there's a change in the wind, for better or worse, depending on your point of view, in the flexibility the federal government is having on the burdens imposed on school districts for the very reasons the questioner mentioned, that a lot of school districts are saying it's not worth the trouble, I'm shutting my website down.
All right. Thanks for that. Anything to add? Any of the other speakers?
This is Linnette. I think we've also heard that OCR is has been getting an extremely high volume of complaints in this area. And so I think they are also challenged, as any organization is, with doing some triage and trying to balance requirement and reason and addressing the valid, trying to get through to address the valid complaints. I know a number of districts who are under consent decrees around this area, and they're certainly taking it quite seriously, even if the requirement itself might seem vague. Certainly feel it both within the district and requirements on vendors coming into the district. So I think, I can't speak to the tone and tenor that may have changed with the administration, but I do know that they are underwater with complaints and trying to triage a bit.
And this is Meghan. I would just add, I totally sympathize with the challenges facing LEAs. At the same time, I do think we can't, be soft on these rules. That I think accessibility is important for every person, whether you have a disability, you speak a different language, and I think it's something that really needs to be prioritized by districts. And I think it's an investment we need to make, and we've got to find smart ways to partner with other organizations that focus on these things, that have resources they can share to help make it easier for districts. I think it's important that we uphold these standards and we don't just kind of go back and say, well, I'm not going to post things because it's really difficult. So I think we've got to kind of all pull together and find innovative ways to make it possible for districts of all sizes with differing budgets.
Yeah, and I would just add to that. I think, if you go back to civil rights history, it's not like we said at some point that because it would cost a lot of money to put cuts in sidewalks for wheelchairs to go down, or to make doors accessible for people, that we said that we no longer could have sidewalks or buildings. I think this is a really issue of a mindset, and especially a new era of civil rights thinking in terms of how we treat invisible disabilities particularly. So do I think that absolutely, we need resources to do that, and that the government has a responsibility? Absolutely. But I don't think that should absolve us from trying to reflect on our own mindset and how we do this better. And I think as we do that, as I mentioned, this is not going to just help our kids with disabilities, but that mindset is going to help all learners who are exceptional in one way or another. So yeah, that's just the only thing I would add to that.
Meghan and Ace, I have a little bit of a follow-up. I was just kind of curious to ask you. One of the things that can come up for LEAs is the issue of cost and resources when they're doing something like creating a website. Can you speak to any resources or ways to kind of incorporate accessibility into a district's website that might be available for folks to actually kind of take action or do this in a way that does make sense? Is there a kind of a middle ground that you guys know of, or any resources you can recommend?
I think that WCAG is a great resource, but also the Web Content Accessibility Guidelines. But also beyond that, if you look at I'm trying to think about what the acronym stands for, but the CAST AEM Center has a lot of great resources in terms of materials. So there's just, yeah, there are examples out there, but it's hard to say in terms of what the resources are, because it basically gets to the function of the website and what you're trying to do, and that I think would be context dependent. So I know that's a little bit of a cop-out. I don't know if Megan has any other resources that she can point to.
Yeah, I mean, I don't have any specific resources, but I do know it is expensive, and I think that's just kind of a reality that schools and districts will need to plan for and budget for. I think, even building websites for our own nonprofit, it requires a really big investment. And so while there are some resources to help you kind of guide you through that, I think it is an expense that just needs to be prioritized.
Okay, thank you. I'd like to kind of turn to one or two more questions before we wrap up here. So we've been seeing more and more cases where parents or students are getting in trouble for recording what's happening at school, often in the context of a student with disabilities, generally a nonverbal student. How should the privacy implications of those types of attempted accommodations be evaluated? Kind of a broad question.
Well, this is David. I can jump in because this is an issue that we deal with regularly. There is a general sense that, at least at the K-12 level, students coming in with recording devices, sometimes unbeknownst to teachers and fellow students, and just recording stuff that's going on, there's something unseemly about it. It seems to be a violation of other folks' privacy. And most school districts in New Jersey, anyway, have policies explicitly prohibiting it. One of the problems, however, is that, at least in New Jersey, it is not illegal to do that. New Jersey is what we call a one-party consent state, and there's a lot of liberality around people recording stuff going on around them, including conversations with other people who may not know they're part of that conversation. So if a student is recording stuff, not letting anybody know, even if it's in violation of school policy, there is, first of all, obviously nothing we can do about it if we don't know what's going on. And it's not even altogether clear that if the student records something and wants to use it as evidence later on, that will necessarily be precluded from doing so, because the irony is that typically you find out a kid's been doing it when they've recorded something happening in class that shouldn't have been going on, whether it's abuse by a teacher or something else, where you have evidence of wrongdoing on the part of a staff member, let's say, that was only captured because a student violated school policy and recorded it. And no one's going to be suppressing that evidence. So it is a problem. Where it becomes a little more touchy when you're dealing with a special needs student, let's say, is where a student wants to use one of these devices. Let's say, I'm forgetting the brand name, but is CPEN the correct terminology? There are recording devices out there that allow kids to record lectures, where they will insist as a matter of right that this is an assistive technology that they should be entitled to use, and even have it written into their IEP. And the law is unsettled, at least in my jurisdiction, on whether a student's need or desire to have that option violates the privacy rights of others. No clear guidance on it yet. School districts are taking a pretty firm position that it shouldn't be going on. Nobody's yet tested it in the courts, but stay tuned. It will be tested at some point.
Great. Thanks, David. And I'm just going to try and get one more question in before we finish. So if any of the speakers would like to add in answers for that question or others, please feel free to do it in the Google Doc. But here goes with the last question. Texas passed a law in 2015 requiring that all special ed classrooms have video and audio recordings if any person in the district requests it throughout each and every classroom in order to avoid the abuse of students with disabilities. What other privacy concerns raised? Is this the best way to deal with this type of issue?
Well, Texas, anybody on the line from Texas? Okay, good, we can talk. Texas has made a policy choice that this is a good thing. They have essentially defined away the privacy concerns by enshrining this right in state legislation. I can tell you from speaking with my colleagues from Texas and around the country that Texas, I believe, is very much of an outlier in that regard. It's certainly not a trend that I see occurring around the country. I think it was that the legislation was adopted in response to a particular set of circumstances that has not prompted similar legislation around. And I know if I were the parent of another student in that class, I would very well be concerned about what's going on in my kid's class being recorded without my consent. And I don't believe it allows parents to opt out under that statute, if I'm not mistaken.
All right. Thank you. And so with that, we are going to kind of bring things here to a close. I'd like to thank each and every one of our speakers, Meghan, Ace, David, Melissa, and Linnette, for their time and for coming on and sharing their insight. I really enjoyed the conversation. I'd like to thank each and every one of you who joined us and listened. If you'd like to do any follow-up, I'm going to leave my email address in the chat for the Zoom room, so stay on and I'll send that along to you if you don't already have it. And we're looking forward to hearing from you and continuing the conversation into the future. So thank you all for your time, and we look forward to hearing more from you. So take care.